Welcome to Dealmaking with Laura DiFrancesco, the ultimate podcast for entrepreneurs and professionals eager to master the art of acquiring businesses. I'm Laura DiFrancesco, a seasoned M&A attorney and founder of Dean Street Law and a few other businesses. Join me as I demystify the complex world of mergers and acquisitions with in-depth insights and practical advice. Each episode is packed full of expertise, featuring discussions on the critical aspects of the acquisition process, from identifying potential opportunities to negotiating deals and successfully closing transactions. Whether you're a first-time buyer or a veteran investor, this podcast equips you with the tools and knowledge needed to navigate the mergers and acquisitions landscape with confidence. Welcome back to another episode of Dealmaking with Laura DiFrancesco. I am so excited to have you here. We are going to be diving into mitigating M&A risks because it is one of the most important components of deal making. So I'm excited for our conversation today. We're going to first focus really on understanding the risks that are involved in M&A transaction, really understanding what they are, how they come up, what their impacts are, and then we're going to talk all about risk mitigation strategies. So we have a blog post on this as well on our website, so we will link that in our show notes. I'm excited to first dive into key risks in M&A transactions. So there are a variety of types of risks. We're going to go into them one by one. They go from financial risks to operational compliance risks and so much more. So we will discuss them one at a time. But to understand them overall, it's important to understand that as the seller, there is always a difference in knowledge between the parties. The seller will always have more information about the business and have a better understanding of the situation than the buyer. And so it is the buyer's job and responsibility necessarily to learn as much about the business as possible, to ask the questions that you need to, of course, to work with a lawyer that will help you in your risk mitigation strategy and to position yourself for success. So there's a lot that you can do to mitigate this risk, but the most important thing first is understanding what risks are involved in order to know how we can mitigate them. So let's dive into financial risks specifically. Now, the financial performance of the business is something that you, of course, have the opportunity to do confirmatory due diligence on. There are a lot of different opportunities to do financial confirmatory due diligence, anything from a full quality of earnings, a quality of earnings light, just reviewed financial statement, confirmation of cash flow analysis. So there's tons of different ways to analyze the historical financial information of the business. But of course, that's all data and may not really show you what you need to know about the business, because that's all of your assumptions are what it will be going forward. And history may not always be a true determinant, and oftentimes isn't a true determinant of what the future will be. It is an influence, absolutely, but there are plenty of external factors that may influence it. So both from an economic in overall point of view, so considering economic influences, if there was a war, how would it impact? If there were geopolitical influences, how would this impact this business? If there were technology changes, how would it influence and impact this business? As well as what is happening in the industry? What's the evolution of the industry? How is it changing? So really understand the economic overall influences, the industrial influences, as well as the business's influences. What makes it have a bad year? Why would this business have a bad year? If, for instance, it is a snow removal business and it does not snow, there may not be business in the winter if they haven't diversified their offerings. So really understanding not just the financial data, but what influences that financial data, as well as unforeseen liabilities. So unforeseen liabilities may occur where there have been issues in the past that have not been disclosed, or there may be information that you don't know. So issues in the past may be with employees or customers or anything like that, or environmental issues. It really depends. That's what due diligence is for. That's what our representations and warranties are for, our covenants in the purchase agreement, as well as your indemnification clauses. For the most part, as well as your deal structure, an asset purchase versus a stock purchase. And of course, an asset purchase includes all of the specified assets and specified liabilities and doesn't include any of the other liabilities, whereas a stock purchase does include all assets and all liabilities unless transferred from the business prior to closing. Well, in those situations, that does seem black and white, but it is a lot more gray than that in practice, because anyone can sue you for any reason. And I love to remind my clients of that. Just because you have an indemnification or a contract does not mean that the situation will unfold the way that you want it to unfold. That's why we do belts and suspenders approaches. If there is a known issue, you would generally want an escrow to be held back from the purchase price and be held in escrow to address that known liability. If there are unknown liabilities, then you may have set off and clawback provisions and or an escrow that are held back from the purchase price disbursement at closing to address those. And then of course you also have your other remedies also. You also have insurance and contracts that the business has been entered into. So there's many ways that I'm diving into risk mitigation already. There's many ways that we can address these, but unforeseen liabilities is one of the most critical elements in the future success of the business post-closing. Overvaluation is another. When you have significant trends in the business, particularly when there is a really high rate of growth, it's hard to know whether that rate of growth will continue. Now, if you're more conservative as a buyer, you may allocate variable seller note or something to bridge that purchase price gap in valuations based on whether something is truly the new norm for the business or whether there's inflation in the numbers due to a particular situation. I think my overall format may be changing as we go through these, because I think it just makes a lot more sense now that I'm thinking through it to go through solutions as we go through issues. And then maybe we'll wrap up with some more solutions. So with respect to overvaluation, you can bridge that purchase price gap through earnouts and through your variable seller note. And you can also have the seller retain a certain amount of equity if they have so much confidence in the growth of the business, then give them a second bite at the apple per se, and they can get the upside through that. So there's different ways that we can address overvaluation, but it's really important to also know what is influencing significant hikes in financial performance, and are those sustainable or are they not? These are a lot of questions that need to be asked. And the other is integration costs. So if you have an existing business and you're looking to integrate an acquisition into your existing business, say perhaps from a roll-up strategy, it's important to know what those integration costs will be. Do you have duplicative team members, duplicative services? Do you need them separate? So really understanding those integration costs is important. Let's dive into another category of information and overall M&A risk, which is lack of business knowledge. Like I mentioned, this is one of the most important ones there is. The seller has so much knowledge in the business, and your job in pre-LOI and post-LOI due diligence is to gather as much information that you can so that you know not only is this a business that you should invest in, and this is a business that you want to buy, but also what you can expect post-closing and how you should be operating the business post-closing and how to operate the business post-closing. So sometimes we have all of these ideas, or I see all of these ideas that a buyer may have for increasing the enterprise value of the business. And something that I do in my businesses that I think is really important is you always overestimate your success in your dreams. But if you're talking about financial projections, always underestimate your success. And I always model things out 3 ways as well. I model it in best case scenario, worst case scenario, and realistic scenario. So as you're gathering your information, start to really have that lens of, does this actually make sense? Is this something that I can stand by? Is this something that I think will endure? And then also, not only should you be asking questions about the finances, but ask questions about culture. Culture is so important in a business. Understanding control, understanding the people. You may or may not have the ability to speak with employees. If you have key employees, you should be speaking to them pre-closing. Whether or not that's pre-signing a purchase agreement or after signing a purchase agreement, you need to be speaking with those folks to have them sign key employment agreements. And it's important to understand the culture of the business. It's also so important to understand the operations of the business. How does the business flow? How does it work? How does it serve its customers? How does it function overall? These are really important aspects to understand, because lack of knowledge is the biggest opportunity for risk, and gathering as much knowledge as possible should be one of your key priorities within your pre-closing timeline and post-closing. That's why we have seller transition agreements, whether that's seller employment agreements, consulting, independent contractor agreements, whatever it may be, to transfer that knowledge of the seller. Typically, you do want the seller around post-closing for a certain period of time to transfer that knowledge. There may be certain situations where you don't, but for the most part, that's true. Thinking about buying a business? Unlock the secrets of successful acquisitions with Acquisition Insights, your legal roadmap for success. With over 81 modules of video lectures, written materials, guides, and checklists, we provide in-depth guidance to navigate every step of the process. From initial interest to closing the deal, get the expertise you need to make informed decisions. You can also access our battle-tested templates in the Acquisition Insights course and templates bundle, including letters of intent, pre-LOI and post-LOI due diligence request lists, material deal terms lists, and more. Visit lauradifrancesco.co/the-shop today and take the first step towards buying your dream business. The other risk that we have, other risk category, is operational risks. So this is potential issues in the business, whether it be with respect to merging it or acquiring it and running it overall. Understanding technology is really important. Not only what the technology currently is, but how much would it cost to replace it? How much would it cost to change it? Not just in dollars, but also in time, implementation, operational disruptions. What platforms does it have? How outdated is it? And then what are some other opportunities and how can you improve it? So those are a little bit of technology. You also want to do the same thing for human resources. And so understand the key roles within the business and who is a key person within the business and who would you need to continue running the business successfully. Whoever you would find to be a key person within the business who you would need to successfully run the business post-closing should be signing a key person employment agreement. That's very important during the transaction process so that you don't potentially lose that person. You may still have that employment agreement say that it's at will, but they may be pursuant to that agreement needing to send you notice for a certain period of time that will enable you to have the time to replace them and train someone new, so it won't be out of the blue. So those human resources element, culture, human resources, technology, more of the essentially fluid and almost goodwill components of the business deserve just as much due diligence and consideration as the financial aspects of the business. So you might be thinking, how can you as the buyer effectively evaluate the management team and operational capabilities of the target company? Ask questions. Ask who does what. Ask what their role is. Ask whether they have standard operating procedures, whether anything's written down. Ask as many questions as you can and have constant conversations with the seller. So while you may not be able to mirror the seller and shadow them and see what they do on a day-to-day basis, because that would of course signal to everyone that there's going to be a change in management, which they may not want. but you can ask the seller to have weekly, every few days, a meeting with you to keep you apprised of what's going on in the business, how they spend their time, who's involved in different scenarios. So the more that you can start to step into the role of the seller pre-closing, I think the better off that you'll be able to have these conversations, understand more about the business, identify the key personnel, and then if you do have the ability to meet with key personnel, have due diligence meetings with them as well. Ask them their thoughts on the technology of the business and whether it's sufficient or whether it needs to be replaced, and have they looked into replacing? Why haven't they replaced it? All of those things. You want to ask as many questions as possible. Now, I will say there's going to be a lot of this that you do post-closing as well. You want to spend the first 90 or so days observing, testing your theories on what you should be doing in the business as a priority, of course, addressing anything that's critical. For the most part, you should hold off on making any non-critical changes, non-time sensitive changes, until you've gathered enough information, until you've really taken the helm and are operating the business yourself and have watched and seen the reason why. And of course, ask the people who will be influenced by your decisions their thoughts, because if they can come up with a 5-second flag of why you shouldn't spend $100,000 on new technology because it just won't work for their role, I think that's important things to consider. Let's dive into regulatory and compliance risks. So regulations and compliance are critical. They are a major legal aspect. If you are buying a regulated or licensed business, really lean onto your legal team to ask them about compliance and about compliance risk. Of course, this will be covered in due diligence, covenants, the representations and warranties, indemnifications. But if there is an issue post-closing, it will be your responsibility to get it set right, because otherwise you might not be able to operate your business. So it's important to, of course, have the seller agree that things have been done well, that there aren't any regulatory issues, but it is also something that you need to, if there is a high risk of regulatory and compliance risk, to engage your legal team to do a compliance or regulatory analysis to make sure that there's nothing that you're missing, because it is very critical to the operation of the business. Compliance costs are something that should be considered in the operating budget of the business. If it's a compliance heavy business, it should have a legal budget for compliance, because it is a critical aspect of continuing the operations of the business successfully. I will note that regulations change all the time, every day, and they are constantly evolving and new proposals are constantly being made. So it is something that needs to be ongoing, which is why I recommend it be a part of your budget going forward. If there is issues of non-compliance that you're aware of, then of course you either need to make sure that they are remediated pre-closing, or that there are plans to remediate them post-closing, and you may have an escrow hold back, or you may have other terms to deal with those compliance and regulatory issues. The next risk is reputational risk. And so this is the reputation of the seller, the investors, the buyer, in the overall customer, in the overall market. It may not be wise to share with your customers that there's been a change of ownership. It may be a lot more wise to quietly change ownership and to not make customers aware. They may not need to be aware, or they may need to be notified, or consent may be required under their transaction documents, under their contracts with the seller. So it's also important to know the stakeholders as well as the shareholders. So who are the stakeholders in the business? That may not be the shareholders. It may be key employees. It may be if the seller has a family and certain family members were intending to inherit the business and operate the business. It may be them. It may be their spouse. It may be other key people in their life. It may be their broker, anyone else, their lawyer, of course. They're all going to have opinions on the business, and then you have to understand each stakeholder's influence on the transaction. Customers, vendors, employees are all very key stakeholders. I wanted to name a few that you may not be thinking of, but of course, always think of your key stakeholders as well, your employees, your vendors, and your customers. And they may heavily influence the transaction. And so you have to know what level of influence they have and how it may impact the transaction. The other element is transaction document risk. The most important thing that you can do to mitigate your risk is to have good transaction documents, because if there is a risk and there is something that happens, the first thing that everyone will do is look at the transaction documents, look at the contract, see what rights they have and who's obligated to do what. And if you didn't invest in good transaction documents, this can be, one, a lost opportunity to recover in the event that you had a right to recover, but two, an absolute disaster in the event that there is either no opportunity to recover or you're in a bad situation and you should have had an opportunity to recover. So you really want to set yourself up for success. Have the right legal counsel who understands mergers and acquisitions, who has deep knowledge of deal making and understands the lower middle market, because transaction documents will be the one thing that people will always go to if they need to resolve an issue. So if you have poorly drafted documents, there may be legal disputes, unmet obligations, unclear terms, and it's going to take so much more time, expense, and resources and headache to resolve it later than it will be to do it right the first time. It always costs, I've seen, anywhere between 4 to 10 to way more times the cost to do it right the first time versus having to remediate later. So you're not saving money by doing it poorly. The best thing to do is do it right the first time and set yourself up for success. So what are some early indicators of risk? It's really important to ask questions and get knowledge as much as you can pre-LOI, post-LOI, absolutely before closing. And so work with your attorney to identify where the risks are. They are literally trained through law school to be phenomenal risk identifiers. It's one of the biggest things that they're tested on in law school and all throughout their career is risk identification. So work with your attorney to assist you in identifying these risks. Of course, use the resources we have. We have this entire podcast, as well as pre-LOI, post-LOI due diligence request lists, and tons of resources within Acquisition Insights. The pre-LOI, post-LOI due diligence request lists are in the Acquisition Insights course and templates bundle. And then we also have over 81 educational modules with videos and written materials, as well as some checklists within the Acquisition Insights course to take you all the way through the process from beginning to end from the legal perspectives of buying a business. So identify them early and you can set yourself up for success. You can have transaction documents that will directly address the concerns that you have. One of the biggest things that people don't realize is, oh, you can just take a template purchase agreement, can't you? No, we have to highly customize every transaction document to address all of our due diligence findings and to address all of these risks that you have within a transaction. And each risk and each transaction and each target has different risks. Everything has a different risk profile. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com to schedule a complimentary consultation. So now that we've talked a little bit about the risks, let's go into some more things that we can do in risk mitigation strategies. This is going to be a little bit more broad, kind of returning back to my earlier conversation. Like I said, investing in due diligence is important. So what can you do in due diligence to position yourself for success? Pre-LOI due diligence is critical. If you have the time for it, if you're in a non-competitive situation, you should always do a first initial assessment of the business yourself. And we do have a pre-LOI due diligence request list on Acquisition Insights course and templates bundle. And that scope of analysis will be to understand the legal operations of the business, the legal structure of the business, the preliminary financial health of the business, the market position, and preliminary reviews of information that's available to you. I also always recommend understanding whether it should be a stock purchase or an asset purchase, understanding whether there's licenses or regulatory components or any issues of transferring ownership that might be influenced by contracts and assignability of key contracts. So all of those are going to be in your pre-LOI due diligence. And that's going to really help you identify key risks early on so that you can shape the structure and terms of the letter of intent as well as all of your transaction documents to address them. Most key risks can be addressed if the parties are willing to negotiate to address them. There are plenty of solutions to address key risks within a business. It just depends on the viability of different various solutions and ideas for the parties. So the question you might have is, what steps can you as the buyer take if the seller is not forthcoming with certain necessary information? If you're pre-LOI, the seller may be very hesitant to provide certain key confidential information, and that's okay. That's why we have the confirmatory due diligence period before signing a purchase agreement, before submitting a purchase agreement. So that is part of why we have that due diligence period, but it is important to get as much information as possible pre-LOI. They may not provide customer contracts. Of course, there's plenty of information they're going to be hesitant about. So just determine what should be pre-LOI and what should be post-LOI due diligence. And if it's a competitive situation, you may not have the opportunity to submit an indication of interest to give them more comfort to gather more information pre-LOI. And so that may be a responsibility to cover post-LOI and to punt it to your post-LOI due diligence. It's okay if they're nervous, and they may even be nervous about providing information prior to signing a purchase agreement. Critical information for the business may be necessary to sign a purchase agreement before. So you may negotiate your purchase agreement, your ancillary transaction documents, and do most of your due diligence, and then have a few elements that you'll need to receive access to post signing the purchase agreement or post submitting a deposit or a non-refundable deposit to get additional access to information. It's really just understanding where the concerns are, how you can address those, and how reasonable they are in asking for those requests. And then also what information should be gathered pre-LOI to ensure a solid foundation for the transaction. You absolutely want to know whether it should be a stock purchase or an asset purchase. Have at least 3 years of financial information available to you, both for your review and for the lender's review if possible, and to look up and search on the Secretary of State website for the registration of the business, and if it shows whether it's in good standing, that it's in good standing, and also how many legal entities hold the assets of the business, and are they all going to be a party to the transaction? Is there real estate involved? Is it held by a third party or the seller? So really understanding the legal lay of the land. And then you're going to get into post-LOI due diligence. And so this is very detailed. You will do your own due diligence for business due diligence, financial due diligence. You may hire a vendor to assist you with financial due diligence. And then, of course, your legal due diligence as well. This is comprehensive. Typically, it's going to take your financial vendor who's doing financial due diligence 4 to 6 weeks if they're doing a quality of earnings, maybe longer if it's a more complex transaction or business. And then your legal team is going to take at least 2 weeks on legal due diligence, sometimes 4, sometimes more, depending on the complexity of the transaction. It really just depends. There's a great deal of difference between a non-complex business and a complex business. And then in addition, you're going to be doing all of your financial or all of your business due diligence as well. We do have that post-LOI due diligence request list in the Acquisition Insights Course and Templates bundle. It's 14 pages or so of questions to be asking. And if you're doing that, you can send it as early on as you'd like so that they can create a data room so that by the time that you're ready to engage legal counsel to complete due diligence, that they are ready to be able to move forward because the data room has been populated. And if you're not aware, typically the data room is where the seller puts all of the confidential information so that only a few people have access to it, and it's organized in a way that responds to the due diligence requests that are being made. That's going to be your comprehensive evaluation of the business. This is going to be your time to really mitigate as much risk as possible so there's as few surprises post-closing as possible, and so that you know what the terms of your principal and ancillary transaction documents will be, or at least your lawyer will know what your terms of your principal and ancillary transaction documents need to be to address and mitigate these risks. So how can a buyer ensure that they have all the necessary documentation and information provided? Using something like a due diligence request list. That's really critical. And then following up with additional questions. It is your right and obligation and responsibility as a buyer to be asking questions during this time. And then you might ask as well, what should you do if you discover a significant issue during due diligence? First off, discuss it with your attorney. There are solutions for everything, and it may not be as challenging as you would expect, because when you have issues that come up, there are so many examples of how that's happened previously that we can show you how we can navigate it, how we can address it, how we can minimize those risks. Ultimately, you'll never be in a position where you eliminate all risks. That's not feasible. That's not entrepreneurship. That's not business. But there's a lot that we can do to eliminate risks and to support you, to better position you in your transaction. How about structured planning? So let's go into integration planning based on what you know about the business. I think it's really helpful to mitigate risks by coming up with an integration plan, coming up with your to-do list of what you want to do post-closing. So how the business will be integrated, if there is going to be an integration, or what your overall roadmap is for the first 90 days if you're just buying the business. So really doing a lot of scenario planning to think of different things that could happen and how you can mitigate those risks. Include timelines, key milestones, resource allocation. Like I said, when we went back to the very beginning, we talked about economic risks, market risks, competitor risks, technology risks, all of those things that are outside of your hands. Coming up with situational planning and protocols can really help mitigate those risks, can really help you understand the significance of those risks, and whether those risks are something that will materially impact the transaction or something that you can just go through and navigate with some sophisticated planning and some good guidance. It's important to go through that process. I think it's important to also know every plan is intended to change. I like to think about business planning, scenario planning, all of these things like I think about Google Directions. Google Directions orient me and tell me where to go. But as I'm driving, it's up to me to realize what's around me and to react to my reality. Google Maps may say that I can continue going straight, but if there's a pedestrian crossing, we need to slow down and stop. If there is someone swerving, we might need to reorient ourselves. If there's a bridge closed that they don't know about, we may need to take a detour. So when you're thinking about business planning, it's so important to know that this is, I would say, even your printed directions that you need to look up and see what's going on in your world and navigate in real time. It's meant to orient you. It's meant to be a resource, but it is not meant to be the Bible that you live by. It's meant to be something that informs your decision-making going forward. How we can navigate risk allocation in negotiations. Risk allocations in negotiations is very important because it can be a true determinant of whether a deal can go forward or not. And a lot of deal-making negotiations is risk allocation. You want to strategically use your negotiations as opportunities to distribute and mitigate risk, such as through indemnifications, representations and warranties, purchase price adjustments, escrow agreements. All of these are tools of how you can address particular risks within the business. If there is a known risk within the business, if there is a claim that is still in the process of being adjudicated, absolutely there should be an escrow for the maximum amount that you would expect that claim to warrant. So there's a lot of legal mechanisms that you can use, and I would encourage you to lean on your attorney. We work with our clients throughout this process. every day to navigate risk mitigations in negotiations. And like I said in our negotiation tips on our last episode with respect to letters of intent, it's so important to not only understand your point of view, your perspective, how something will influence you, but also to understand seller's point of view, the seller's perspective, and how something is influencing them. Understanding their deeper motivations can really help you to allocate risk appropriately and also know market terms, and your attorney will know market terms. So when you take all these factors into consideration, you or your attorney, who's very well versed in this, can come up with creative solutions to deal making and to negotiations to strategically allocate risk in a way that is fair and also positions you well for success. With respect to that last item on regulatory compliance, effective transaction documents will help you tremendously, as well as good due diligence. If you have a highly regulated business, it's important to invest in due diligence so that you can understand where the common pitfalls might be for this type of business, where there may be issues that it's not compliant already, and make sure that your transaction documents clearly allocate that risk. If there's remediation that needs to be done pre-closing as a closing condition, that may be one way to solve for it. If there is compliance risk pre-closing, how should that be addressed through an escrow? If it's known, or if it's not, maybe set off in clawback provisions. How will that influence the transaction documents? I hope this has been helpful, sharing this information with you about key risks in deal making. I hope that it has helped to elevate your deal making skills and make you even better at negotiations, at deal making, and hopefully guide you in the process of buying or selling a small business. It's so important to be proactive in risk mitigation. It can really be a true determinant whether you're set up for success post-closing. I hope this has been helpful. Thank you so much for joining me for this episode of Deal Making with Laura DiFrancesco. I look forward to seeing you in the next episode. Thank you for joining us on this episode of Deal Making with Laura DiFrancesco. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please make sure to follow and subscribe to Deal Making with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please make sure to leave a 5-star review and share the podcast with anyone who may benefit from it. Sharing our podcast is the best way to show your support and help us to continue making more content just like this. So please be sure to take a screenshot and tag us on social media whenever you can. For more in-depth resources, be sure to visit our website at deanstreetlaw.com, where you can find articles, guides, and more information on our services. Or you can also visit lauradifrancesco.co/the-shop for more information on our legal courses. Don't forget to follow us and connect with us on social media for the latest updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Be sure to join us on our next episode, where we'll be discussing more deal-making tips and insights. I'll see you there.